Stevenson and Ravenwood Homeowners Association. Do I have parties present on this case?
Yes, Mackenzie Schmidt on behalf of defendants.
Robert Johnson, pro se, plaintiff.
Okay, so plaintiff has moved for leave to file an amended complaint. Defense is objecting, correct?
Yes, Your Honor.
Okay. So Mr. Johnson, go.
A homeowner walks into court determined to revive a lawsuit against his homeowners association after previous claims were thrown out. He argues that justice requires another opportunity, insisting his new complaint is different from the last one. But from the very first questions, it's clear the judge isn't ready to simply reopen the case. What begins as a routine motion quickly turns into a tense legal showdown over whether this dispute deserves another chance.
Go ahead with your argument.
Plaintiff asked for leave to amend under CR 15A. Under the rule, which it advises leave should be given freely when justice requires it. The proposed amendment doesn't simply refile the dismissed claims. It's a response to the prior court's rulings in the summary judgment motions. I do not plead county code violations as standalone causes, conversion, or seek restitution for unpaid amounts. And it also does not assert a generic ultra vires damages claim. It preserves the roadway drainage claims through the breach of governing documents, nuisance, negligence, and pleads that arise later or late arising disputes that occurred after the initial complaint was filed. And those disputes involve the current balance the defendant claims that is owed, attorney fee charges, common expense classification, collection exposure, and contested corporate actions. Those have not been adjudicated on merit.
The HOA's attorney pushes back hard, arguing that nearly every issue has already been decided by another judge. She claims the homeowner is simply repackaging old arguments under new legal labels and warns that allowing another amendment would waste the court's time. As each claim is challenged one by one, the courtroom shifts from a procedural hearing into a battle over whether the lawsuit has any legal future at all.
Let me ask you specifically, as it relates to your claims for violation of RCW 6438, how was that not addressed in Judge Scudder's ruling?
From 60, they're not standalone claims any longer. It's just a declaratory relief that let me see. Trying to find. It was those claims were found derivative because they were found to be affecting more than just my own interest in the HOA. So they were not found individual. That's why they were brought under RCW 24039 or 03A966, because at the time I had not pled this for a judicial review, so it could not be addressed during summary judgment.
Is there anything else you want the court to know?
The homeowner refuses to back down, introducing allegations involving HOA leadership, attorney involvement, disputed fees, and possible conflict of interest. He argues that internal HOA remedies cannot fix what he believes are deeper governance problems and asks the court for independent judicial review. The accusations raise the stakes. forcing everyone in the courtroom to focus on whether these issues truly deserve another hearing.
No, Your Honor.
Okay. Ms. Schmidt, go ahead.
Thank you, Your Honor. Defendant's position is that most of these arguments have already been addressed and disposed of on summary judgment and motion to dismiss. Here, amendment would be futile. Your Honor has already pointed out that the RCW 64.38 claims were already dealt with. In addition, Judge Scudder specifically found that declaratory action was inappropriate where he had alleged contract and tort claims that have viable relief. And the contract claim in this revised version of this proposed amended complaint includes a laundry list of all of the complaints that he's seeking relief on, including voting, including approval for various procedures, financial controls, imposing and collecting fines, all of it. So the 3 new declaratory action claims are already brought in that contract claim. Additionally, this new proposed complaint seeks to assert a tort of an unknown species against Jim Hutchinson. There are no elements of a tort alleged. It tries to characterize it as an intentional tort. However, there's no facts that support intent whatsoever. There's only an assertion of knowledge, which knowledge in and of itself is not enough to create an intentional tort. And as to the final new claim,
As both sides finish their arguments, the judge begins asking direct questions that cut to the heart of the case. The discussion shifts away from technical legal rules and toward a simple issue. Where is the actual evidence of harm? Previous rulings are repeatedly referenced, and the homeowner struggles to convince the court that his latest filing overcomes the same obstacles that defeated his earlier claims.
Review under 24.03a.966. The relief afforded under this statute is very narrow. And the relief specifically that he seeks under this claim is really just a collateral attack on defendant's right to assert itself, right to a defense. He seeks to invade the attorney-client privilege by looking into any conflict waivers, bills, things of that nature. It's not actually targeted at any other additional corporate action. And furthermore, there are mechanisms already in place in the CC&Rs and by statute for where he could attack these alleged actions by the board that are improper, but he has not sought to do any of those. There are special meetings he can call. The directors can be recalled without cause. There is a budget procedure under RCW 64.38.02525, not 025, all of which he could avail himself of and has not done so. So between the 3 declaratory actions, the tort of an unknown species, and judicial review under the statute, any of these amendments would be futile. And additionally, I would like to note for the court that plaintiff's motions to amend the certificate of service indicates that we were served on May 7th. We were not. We do not have an e-service agreement despite asking for one. He did email me a copy on May 8th, and we researched the history of the mailing, and it appears that a label was not created until May 8th, and it was not put into the mail until May 9th, based on everything we can see. But the certificate of service signed under perjury indicates that it was filed and served to us on May 7th. Just want to note that for your honor. That's all I have for the court. If you have additional questions, I can answer.
Mr. Johnson, anything in response?
Yes, Your Honor. With the proposed complaint, specific corporate actions, counsel retention, such as counsel retention, the use of association funds, the attorney fee classifications, the assessment fees, the director appointment, and the seat issues, and the enforcement of the disputed balance. Those issues are what's being alleged under the ARSA, or as is why the plaintiff is bringing RCW 2403A 9664. The remedies that the defense suggested, the defendant wouldn't.
Rather than ruling immediately, the judge announces that a written decision will follow. Before ending the hearing, however, the court delivers a powerful warning that captures everyone's attention. The judge reminds both parties that judicial resources cannot be used to repeatedly relitigate issues already decided, and suggests that future filings lacking legal or factual support may bring consequences. The hearing ends quietly, but the judge's final words leave the strongest impression of the entire case.